Thank you, Madam Chair. A real pleasure to be back at your committee, and Madam Bennett, always a pleasure to discuss. Even though we sit across from each other, we don't get to talk, except maybe when we're shouting at each other off record. Last week, I was at Ontario Superior Court with former Chief Edmund Matatawaban and the survivors of St. Anne's Residential School because they brought forward an appeal on non-disclosure of sworn evidence that's in the hands of the Government of Canada. And that evidence comprises the sworn testimonies from the survivors of Indian residential schools relating to the child abuse, sexual assault, and other crimes that was obtained by Canada prior to the settlement agreement of 2006. Because it's been the surprising thing that's come out of the St. Anne's hearings is that the government is in possession of documents relating to 14,000 civil actions that were brought by survivors, some of them from St. Anne's, but from across Canada. Can the minister tell us if those transcripts of examinations for discovery from plaintiffs suing for institutional child abuse prior to 2006 were disclosed to the Truth and Reconciliation Commission before it was extinguished?
So, as you know, there were concerns about documents that hadn't been disclosed. Our government has disclosed, and Justice PERRELL has said that everything has been disclosed at now, and he has said that it is that Canada has not been is holding up its side of the bargain now, and so it
We're
says,
talking about different documents.
But
We're not talking about. We're not
Can-
sorry.
yeah.
I just so we don't go down the rabbit hole. St. Anne's had to go to court because the government suppressed the 12,000 pages of documents of the crimes at St. Anne's Residential
the
School.
previous government.
Your government went the whole distance, and they still so. But I'm talking about the documents relating to the 14,000 cases that were brought for civil action prior to 2006 that became apparent during the St. Anne's hearings that the government has those documents but has not apparently turned them over to the Truth and Reconciliation Commission. That's a separate set of documents. 14,000 cases of civil action. Were they turned over to the Truth and Reconciliation? Is the government sitting on them? Why?
My understanding is that the Government of Canada has turned over any documents that the court has asked for, and we are now, as Justice PERRELL said, have held up what evidence shows Canada has kept its promise and continues to keep its promise. That's the problem.
Okay, but
Charlie,
but I'm talking about different documents. I'm not talking about the suppression of the evidence of the crimes committed at the children at St. Anne's. I'm talking about all the cases that were brought forward for civil action that the AFN then signed on, thinking that all these prior cases, what happened to them? Because before Justice PERRELL, your lawyers argued that none of these 14,000 cases could be brought to the IAP, and he agreed because the government declared settlement privilege and said, well, these were separate documents, and Justice PERRELL certainly agreed with you. But when I was at Court of Appeal, the judges asked your lawyers, do you have any proof that there was settlement privilege posted on these 14,000 documents? And they said no. So Justice PERRELL was told a falsehood about settlement privilege. Why would you claim settlement privilege on these 14,000 cases that are evidence, that are proof, that in the case of Angela Shashish could help other cases? Why would the government claim settlement privilege?
In these individual cases, you obviously are there, and I believe Ms. Shashish has received a settlement. I think the issue is that there is an integrity to the URSA process that needs to be maintained. Otherwise, it will all go tumbling down.
I think that's the concern.
What we're trying to do is to anybody who has not been properly served by that, we're trying to get them whatever they need to be properly compensated.
But Madam Bennett, that's not true. You went to BC Superior Court. You went to BC Superior Court with your factums that are still under secrecy, which stated that the right of procedural fairness did not apply. You're not saying if someone was denied rights, you're saying they don't have the right to come back because the government suppressed evidence. That's not a process of integrity. That is a fundamental undermining, and that's why St. Anne's won't go away. But I am talking about the documents, all the evidence that your government claimed recently to Justice PERRELL, and he accepted your argument about settlement privilege when settlement privilege is not applicable because you don't have settlement privilege. Why would you say that?
I think we have said that if Mr. Sheesh or anybody wants their documents with the TRC, that is absolutely their right to table them with the TRC. So that's,
So
as
it's an
you know,
individual
our
choice.
concern is that the Supreme Court has now decided that some of those, or they will all be destroyed if people don't give individual pressure.
But the
permission.
Supreme
I
Court
just wanna add
wasn't
one
informed
point. Yeah.
about these 14,000 cases that were settled prior to 2006, were they?
I just wanted to add one clarification. The pre-URSA documents are covered by settlement privilege, but if the claimants want us to waive that privilege, we will waive that privilege.
Okay, that's interesting because I was pretty sure what I heard in the Court of Appeal, they asked your lawyers, do you have any proof that any of these are under settlement privilege? And they said no. So you claim settlement privilege to deny access to St. Anne survivors.
Again,
so if you say you've got settlement privilege, you have settlement privilege. If you don't, you're undermining the process. That wasn't the question. The question was, do you have proof that settlement of privilege was applied? And it wasn't. So I just want to move on from this. Did you get any advice from the 9 supervising judges on the Superior Courts about the legal obligations to disclose these sworn testimonies that were gathered in the cases prior to 2006? Because there's an enormous amount of evidence there and documentation. That should have been part of the IEP. That should have been part of the Truth and Reconciliation. It seems to be sitting in someone's drawer at the Justice Department. Did you get any legal review or advice?
Just a couple seconds.
I'll just
Yes
say
or no?
that the IAP doesn't apply to every case of abuse, and we have worked and we continue to work to address the cases of abuse that are not covered by the IAP. It was never designed to cover every single instance of abuse.
It was designed to follow the law.
Except that 98% have been resolved, and we're working very
Sorry.
hard on the 2%, which are obviously the most difficult.